This is DevAI, focusing on the newest developments in AI and the legal space. Please subscribe to my channel. Fair credit reporting is of major importance for many individuals, given that wrong information that is provided to credit agencies may significantly harm the individuals in getting adequate business deals and loans. The case Spokeo versus Robbins is an important one in this regard. This case presents the question whether respondent Robbins has standing to maintain an action in federal court against petitioner Spokeo under the Fair Credit Reporting Act of 1970. The Fair Credit Reporting Act, FCRA, is a federal law that helps to ensure the accuracy, fairness, and privacy of the information Consumer Credit Bureau files. The law regulates the way credit reporting agencies can collect, access, use, and share the data they collect in your consumer reports. What is the purpose of the Fair Credit Reporting Act? Passed in 1970, the FCRA helps consumers understand what actions they can take in regard to the information in their credit reports. Information is being gathered about consumers all the time. In addition to the three major consumer credit bureaus, there are other organizations that may collect and use your information. For example, banks and credit unions may use information from your credit history to determine whether to approve you for a loan. Why does it matter how information about your credit is used? Whenever you apply for a credit card, a car loan, a mortgage loan, or any other form of credit, the issuing company checks your credit history to assess your credit worthiness. The terms you are offered for credit, such as a loan, may be based in part on your credit score and information in your credit report. Your credit history affects more than just your ability to get loans or the annual percentage rate on your credit card. For instance, prospective landlords could check your credit report to see how creditworthy you are when deciding whether they can trust you to pay your rent on time. In some states, employers may check your credit report for hiring purposes. Also, depending on the state, insurance companies may check your credit to determine whether to offer you coverage. But how does FCRA help consumers? The FCRA helps protect you by regulating how information in your consumer report can be used and accessed. Here's an overview of the key aspects of the law. The FCRA gives you the right to be told if information in your credit file is used against you to deny your application for credit, employment, or insurance. The FCRA also gives you the right to request and access all the information a consumer reporting agency has about you. You can get one free file disclosure every 12 months from each national credit bureau by going to annualcreditreport.com, for example. The FCRA gives you access to your credit report but restricts others' access. In general, access is limited to people with a permissible purpose, such as landlords, creditors, and insurance companies. If an employer wants to see your credit report, you must give written consent. Employers must meet other requirements as well, and not all states allow employers to pull credit reports as part of an applicant's background check. If you find what you believe to be inaccurate or incomplete information on your credit report, you have the right to dispute it. The credit bureau will then contact the data furnisher to confirm whether the information is correct. If it's not, the credit bureau will either correct it or remove it within a certain time period. Accurate negative information, such as bankruptcies and late payments, will be removed after a certain time period. The FCRA gives you the option to opt out of the pre-screened offers of credit you receive. Finally, the FCRA gives you the ability to put a security freeze on your credit report, which ensures that potential lenders cannot check your credit report without you first lifting the freeze or providing the specific lender with a one-time PIN to access your credit report. The question is, however, can AI be wrong? And this is well outlined by Spokeo Incorporated vs. Robbins, 2016. That was a United States Supreme Court case in which a court vacated and remanded a ruling by the United States Court of Appeals for the Ninth Circuit on the basis that the Ninth Circuit had not properly determined whether the plaintiff had suffered an injury in fact when analyzing whether he had standing to bring his case in federal court. The court did not discuss whether the Ninth Circuit's ultimate conclusion that Robbins adequately alleged an injury in fact was correct. On May 16, 2016, the Supreme Court delivered the judgment in favor of Spokeo, vacating and remanding by a vote of 6-2. Justice Samuel Alito, joined by Chief Justice John Roberts, as well as other justices, wrote that the circuit below had failed to establish that Robbins had standing to file the lawsuit under the Article 3 of the United States Constitution. The court first explained that the Constitution's case or controversy clause requires any plaintiff to allege an injury in fact, that is, a concrete and particularized. While the Ninth Circuit identified particular harms to Robbins, it erred, according to the court, by not also determining that those harms were concrete. Although intangible harms such as risk can be concrete, the court clarified bare procedural violations cannot. The court remanded the case while taking no position as to whether the Ninth Circuit's ultimate conclusion, that Robbins adequately alleged an injury in fact, was correct. However, on August 15, 2017, the Ninth Circuit again allowed Robbins' lawsuit to proceed. Judge O'Scanlan, joined by the same judges as before, now found that Robbins had alleged a sufficiently concrete harm to establish an injury in fact under the Constitution. Relying on an amicus curiae brief filed by the Consumer Financial Protection Bureau in support of Robbins, Judge O'Scanlan determined that publishing even flattering inaccuracies could harm a job seeker. Spokeo again petitioned the Supreme Court for writ or certiorari, but this was denied. The outcome of this case is very interesting. It states that general companies are responsible for the IT they deploy, and the Spokeo vs. Robbins has shown that the publication of false information can be sued in court. So this case will definitely go on in the future and will be a very important precedent for future cases to come with respect to this. This is Definitely AI, focusing on the newest developments in AI and the legal space. Please subscribe to my channel and put any question or feedback in the comment section below. Goodbye.